It's a legal principle that even where a single shareholder virtually holds the entire share capital, a company is to be different from such a shareholder. That's the precise discussion in Solomon versus Solomon and Company Limited, and the discussion continues in this case law as well, which is Lee versus Lee Air Farming Limited. Here in this story and in the first part of it, we need to understand that a person by name Lee formed a company and he named the company as Lee's Air Farming Limited. This company was into fertilizers on farmland from the air, which is known as top dressing. The total share capital was 3,000 pounds, in which 2,999 pounds worth share capital was held by Lee himself. He was the sole governing director of the company and had absolute control over the Lee Air Farming Limited's business affairs. The second part of the facts are very interesting. Lee was not just governing director of the company, but was also chief pilot of the company, as he himself was a qualified pilot. He drawn salary for being chief pilot of the company. His company also had an employee insurance. One day, while he was doing his duty in the plane got accident and he died, which I have mentioned in the third part. And then the fourth part, his wife Catherine Lee claimed insurance amount of 2,430 pounds under the Workmen Compensation Act 1922, as the insurance that company has covered the risk of both injury and death of company's employees. The question then was whether Lee was an employee of the company. Insurance company told he is the governing director and the insurance hadn't intended to cover him but only the employees. The same was upheld by the Court of Appeal. However, the Privy Council gave judgment in favor of Catherine Lee, saying that it was perfectly possible for Mr. Lee to have a contract with the company he owned. The company was a separate legal person. That's the story of Lee versus Lee Air Farming Limited.